Good morning, everyone. We're going to go ahead and go through this morning's docket. Mr. Thomas, I'm going to take your case up first because it looks like yours is uncontested and ready to go. Your client here, Mr. Thomas? You're muted, Mr. Thomas. Okay, ma'am, if you would please unmute for me and raise your right hand to be sworn. Oh, we have both parties here. Is that correct?
Yes.
All right, if each party would please raise their right hand and unmute for me to be sworn.
Need to unmute, Omalara. Yes.
Thank
Unmute.
you. And please raise your right hand. Each of you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
All right, thank you. Mr. Thomas, you may proceed.
Ms. Omalara, prior to filing your petition, could you state your name, please?
My name is Omalara Omowumi Elumelu.
Okay. And prior to filing your petition for divorce, had you lived in Texas for 6 months?
Yes.
Had you also been a resident of Fort Bend County for the immediately preceding 90-day period?
Yes.
And were you married to Peter Omalara on or about April the 2nd of 2005?
Yes.
And you ceased to live together around April the 4th of 2020, is that correct?
That's correct.
There was one child born during the marriage, is that correct?
That's right.
Were any other children born or adopted during the marriage?
No.
Are you expecting a child now?
No.
And you and your husband were able to reach an agreement as to the conservatorship of that child, is that correct?
That's correct.
And you've agreed that y'all would be appointed joint managing conservators and you'd be the parent establishing the residency of the child within Fort Bend and contiguous counties. Is that also correct?
That's correct.
You've also agreed that your husband would have what is known as a standard possession order with a provision that right now, until he gets an appropriate place for the child to spend the night, he will have day visits. Is that correct?
That's right.
And in fact, he has been visiting the child on a regular basis during during your separation, correct?
That's correct.
Y'all have also agreed to an amount of child support of $1,002.86, and that would begin October 1st of this year?
That's correct.
And you presently have the child covered on your medical insurance and will continue to carry the child on your medical insurance, is that correct?
That's correct.
And your husband?
That's correct.
Your husband has agreed to cash reimburse you the amount of $116.81 a month. Is that
That's
correct?
correct.
You have also agreed.
That's correct.
You have also agreed to split uninsured expenses 50-50.
That's correct.
Do you believe those orders to be in the best interest of your daughter?
That's correct.
And you and your husband have previously entered into a partition and exchange agreement and had at that point divided all your assets. Is that correct?
That's correct.
All right. And also, if there was any personal property that was accumulated that wasn't captured by that partition agreement, you're going to be awarded your personal property and he would be awarded his personal property. Is that correct?
That's correct.
Do you think that's a fair division of your things?
That's right.
All right. You're also asking the court to restore your maiden name. Is that correct?
That's correct.
And you're not asking the court to restore the name to avoid any legal obligations, are you?
No.
All right. And are you asking the court to grant the divorce today because of a discord or conflict of personalities. Is that correct?
That's correct.
Is there any chance of reconciliation?
No.
All right, Judge, I pass the witness at this point.
Sir, do you have any questions of your wife?
I don't, Your Honor.
Okay. Mr. Thomas, you may call your next witness.
Yeah, I'll call the Mr. Peter Umalua. Mr. Peter, have you had an opportunity to hear the questions that I asked your wife?
I did.
Yeah, and if I was to ask you the same or similar questions, would your answers be the same?
For the most part, yes.
Well, let's go back. You had an opportunity to read the divorce decree and you looked it over and had a counsel actually go over it with you. Is that correct?
Yes,
And you've signed it freely and voluntarily. Is that correct?
that's correct.
All right. And you also actually executed a waiver in this. Is that correct?
That's correct.
All right. So do you think the orders right now are in the best interest of your daughter?
I believe so, yes.
Okay. Judge, I pass the witness at this point.
All right. Anything else that you'd like to add, sir?
Your Honor, at this point, no. But I do have a question I wanted to ask you.
Well, I'm going to go ahead and let you know before you ask the question that the court's approving all the agreements that the two of you have reached. The lawyer's done an excellent job on the paperwork. Everything's in order, and the court is granting the divorce. I'm also granting, ma'am, your request for your name to be changed. I've signed your final decree of divorce, and I signed the income withholding order as well. Sir, did you have a question you wanted to ask the court?
Yes, sir. Your Honor, so my question is just regarding the income withholding order. Just because I already notified my office to expect a letter in the mail, and I just wanted to have an idea of when exactly. I know the Attorney General's office is responsible for that, for the reimbursement, but I just I wanted to have an idea of the time frame.
Well, I don't really have any control over that. What'll happen is Mr. Thomas more than likely will fill out a piece of paperwork with the district clerk's office asking that order I just signed be submitted to your employer. There's, I believe, a $15 filing fee. Once that's paid and that request is made, they'll send it to your employer. So really just sit tight. Normally it happens pretty quickly.
Thank you, Your Honor.
All right. Thank you all. Y'all have a good weekend.
All right. Thank you.
Thank you, sir.
Thank you.
Am I good to dismiss, Your Honor?
You are.
Thank you.
All right, Mr. Lamos, I wanted to come back to you as well, because your case, I did see that there was a motion, an agreed order of substitution yesterday, and the court went ahead and signed off on it, even though the lawyer that's being substituted out, they hadn't signed it, but all the players that are still in it had signed. So I've got that, but it sounds like from what you said at docket call, you just need to notice the entry date to the other side. Is that kind of what we need to do to finish it up? Because I know you've got an MSA, you're entitled to judgment on the MSA, but I don't think we've had an entry date set yet.
No, we have not. There was one set. I didn't get notice of it. I just accidentally saw it yesterday. It was set for today. The former counsel for Lisa Diaz, I guess, set it without telling anybody. I don't even know if she told her the new attorney substituting in, because they're not here.
I want to finish it for you, but my thought is probably the best way to do this is we set entry for October 29th. You send out notice to new counsel, and then we take the entry up on the 29th at 9 a.m. if that date works for you.
Yeah, I'll make it work. It's just they were ordered, I guess, in the MSA. They agreed to prepare the petition. I kept asking for it, so I don't have anything at this point. I'll let them know they're supposed to do it, but as a fallback, I guess I can do it. But I've got a couple of trials coming up, so the following week would actually work better if I end up having to do it.
Well, let's do that then. Because I know
I'm afraid I may end up having to do it.
Well, and if that happens, we'll deal with any issues that causes. But normally we're going to give you 2 resets, and then on the third one, we're going to start saying, hey, look, we need the order. So you probably don't need to draft before this next entry hearing. But I'm going to give you November the 5th at 9 a.m. And then if it doesn't,
it works perfect.
If you don't get it by then we'll deal with that on the 5th. Okay. Good luck on your trials. Have a good weekend. Thank you,
Judge. Have a good weekend as well.
Okay. Mr. Ramos and Ms. Lusk, have y'all had the opportunity to talk? Do I need to put y'all in a breakout room or are y'all ready to go?
Nope. We're ready to go.
And
We
how
are
long do y'all
ready.
anticipate for your entry?
Judge, I have 5 minutes, probably, Judge. I only have 2 issues. They're very, very
Okay.
short.
All right, I'm probably coming back to y'all next, but let me just get time announcements from lawyers. Mr. Zan, since Mr. Covington didn't show up, I signed your order, your proposed order on the Covington matters.
Riser.
Completed, riser. So I know you and Mr. Kincaid still have an entry. How long do y'all anticipate on y'all's entry? And do y'all need another breakout room to continue talking?
No, Judge, we spoke. I think we need to go to you to get some clarification on some of the points of your ruling, and maybe you can refresh some of our memories because we're a little, I guess, hazy on some of the orders. And I think that'll clarify a lot of the issues. And whatever you say is what we're going to follow, Judge, because we've got different notes taken, just
Sure.
dates on which payments were to be made, and then some clarification regarding the mailbox, Judge. So I think if you can provide us some guidance, it'll be a non-issue after that.
Sounds good.
Think
How long do
less-
y'all anticipate?
Less than 15 minutes, Judge.
Okay. And then Mr. Alonsky and I don't see your opposing counsel.
Good morning, Judge. Right, he was in the other Zoom meeting. I do
Yeah, I
see his
saw that.
client. I do see Ms. Patel, or I assume that's Ms. Patel, and Mr. Bakker is here too under the name Malik Musa. But this is an uncontested prove up. We have the we have the decree in the BVS file with all signatures. So if the court would have us proceed.
Text or call your opposing counsel, because I would normally take y'all up next and get you on your way, but I'm going to need him here. So if you can just, I'll give you a couple minutes, see if you can call him and see what's going on. Maybe he wrote down the meeting ID number incorrectly or something. And
I'll
take
do
y'all
that now,
up next.
Judge.
Okay, thank you.
Thank you.
While we're waiting on him, I'm going to go ahead and get my record set up for, or Mr. Ramos and Ms. Lusk, do y'all need a record on the entry?
I do not.
I don't.
I don't.
Okay,
don't.
Ms. Lusk, you said you don't?
No, I don't either, Judge.
Okay. All right, since this is only going to take 5 minutes, I'm going to go ahead and take y'all on up. Mr. Ramos, if you can just point out the issues that you have with Ms. Lusk's order, and then we will give Ms. Lusk an opportunity to respond after each one.
Yes, sir. Judge, briefly, just page 16, Judge, of her proposed order
I'm there.
on the general terms and conditions. I am looking at number 2. And essentially, Judge, that is in conflict with the previous order, which is on page 13, subsection 2. And under the previous order had the standard language where you're going to have primary custody, but if so long as we both live in the same county, but if somebody moves, then now consequently you have to do the driving. So that's what happened with mom. She ended up moving. So consequently, then mom was dropping the kids off and picking up from dad at his end of his period of possession. So the way that the new order reads, it doesn't reflect that. So that was my issue with the judge.
Go ahead.
All right, Ms. Lusk, response?
Judge, I don't know, she might have moved, but I'm trying to figure out if she lived, if it should have said in the same county or same geographical domicile restriction, it should have said in the first one. So I believe she stayed in the domicile restriction, so he should drop the kids back off at the home. They're having an issue about that because he doesn't want to bring the kids back home.
So it deals with the
On the
county,
return.
not the geographic restriction. So if she moved outside of the county, then she's responsible for one leg of the exchange. And so that this order is going to need to be consistent with that. I understand she didn't move outside the geographic restriction, but if she moved outside the county, then this language needs to be changed on page 16.
Well, I think they're still in the same county though.
I don't, Judge.
He's in Fulshire, right? And she's in, where's she, Katy? I'm out of town, so I don't have the file in front of me, but I think she's in Katy, right?
Judge, they're not, and that's the issue that came up. I think mom contacted my client, you know how it goes, and says, hey, now you got to come pick up the kids from me. And he's like, well, wait a minute, you have moved out of the county and we're going under that provision. So that's why it's an issue. So,
But that was an old.
Well, it doesn't matter because that was what the prior order was because of the move. And so that language needs to be changed.
But what about if she still lives in the same, what if they live in the same county now? That's what I'm saying. I think
that Mr. Ramos said they don't. Correct, Mr. Ramos?
I don't think that's true. I'm doing a hearing. I think they are in the same county.
I don't feel bad.
The court's order is if they're in separate counties, then that language needs to be changed. If they're in the
But
same
I don't think they are.
counties-
Yeah.
If they're in the same counties, then we would need that language that was in the underlying prior order that says if she were to move at, you know,
I understand, Judge.
responsible for the leg, but it sounds like they're in separate counties. So if that's the case, that language needs to be changed to reflect what was in the prior order.
Okay. And then Judge, the second issue, if I may, is really, really quick. It's probably for my own educational purposes, really. I have the order that's drafted has the provision on child support on page 18. And, you know, number one is just one of the termination provisions under the family code. Child reaches 18 or graduates from high school, whichever occurs later, and then subject to the provisions for support beyond the age of 18 years set out below. Okay, my issue is that a presumption, or does that shift the burden, let's say, to the custodial parent if they want the child support to continue past 18 because the child is in fact enrolled in an accredited school pursuant to the educational code, which is an exception to the family code? Is that parent, then do they have the burden to come to court in order to have that evidence in front of your honor so that child support can continue, or it's a legal presumption that so long as then it continues?
I think it's a legal presumption it would continue so long as, and if someone has an issue with that, then they would need to file a motion to terminate the income withholding order and terminate the child support obligation.
Got it, Judge. And the other issue, I think it was for my client, is that it is standard for the child support obligation to follow as an obligation of his estate only. And that doesn't tack on his wife for the responsibility. So I was just trying to explain that to him.
Correct.
Those are my only issues, Judge.
So it sounds like we can make this one minor change. If I give y'all an entry date for 10/29 and y'all just get the order in before then, but 10/29 at 9 a.m., does that date work for you, Ms. Lusk?
Yes, Judge, except we're already having an issue because he's saying he's not going to return the kids on Sunday, that she has to come and get them. And I'm not home, so I don't know. I thought they were in the same county.
Well, that's something that's easy to determine. And now with the court's ruling that you should be able to admonish your clients appropriately. And Mr. Ramos, does 10/29 work for you?
Yes, sir, it does.
Okay, y'all are reset then for entry 10/29 at 9 a.m. And
Okay, and I'll have my secretary find out and call Mr. Ramos, okay?
Okay.
sounds good. Thank you both.
Thank you, Judge.
Okay.
You have a great
All right.
week. Am I excused?
Thanks, Ed. Okay, thank you. Bye-bye.
All right.
Thank you.
May we be excused?
You may.
All right, thank you.
Mr. Alansky and Mr. Mavono, let's go ahead and take up y'all's prove up.
How'd they call you? Well,
Ms.
then how do you know?
Ms. Patel, if you would please start your video. All right, Ms. Patel, if you would unmute for me and raise your right hand to be sworn. Do you solemnly swear or affirm the testimony that you're going to give in this call will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Mavono, are you the one doing the prove up, or I'm sorry, we have Mr. Is it Bakar? Or I guess it's Musa. Sir, I didn't realize you were on here. I'm sorry. If you would please unmute for me as well and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give in this call to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And Judge, I was going to do the prove of, at least
Okay.
I thought so. I didn't mean to interrupt.
Sure, you may proceed.
Thank you, Your Honor. In that case, I call Mr. Bakar. May I proceed, Judge?
You may.
Thank you. Mr. Bakar, can you hear me okay?
Yes, Mr. Easy.
Please state your full name.
Malik Musa Bakr.
Are you presently married to the petitioner in this case?
Yes, sir.
And has the petitioner been a domiciliary of Texas for the preceding 6-month period? And a resident of this county for the preceding 90-day period?
Yes, sir.
And were you married on March 29, 2019, and you were separated on or about May 19, 2021, correct?
Yes, sir.
Okay. And on June 22nd, 2021, petitioner filed her petition to annul the marriage. And then you filed your answer counter petition for divorce on July 10th, 2021. Is that correct?
Yes, sir.
Okay. And the petitioner has filed a non-suit on September 23rd, 2021. Is that correct? For her annulment, correct?
Yes, Mr. Easy.
And since then, the parties have come to an agreement as to the divorce, correct?
Yes.
Okay. Has the marriage become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes, sir.
And there is no reasonable expectation for reconciliation, correct?
No, sir.
No children were born or adopted during the marriage. Is that correct?
Yes, sir.
Have you entered into an agreement concerning the division of your property and debts between yourself and Ms. Patel?
Yes, sir.
And you believe this agreement to be fair and equitable to both yourself and Ms. Patel, correct?
Yes, sir.
You have submitted an agreed decree of divorce, which bears the signature of both yourself and Ms. Patel that enshrines that agreement, correct?
Yes, sir.
Are you asking the court to grant a divorce today and approve all the agreements that you have entered into with Ms. Patel?
Yes, please.
Okay, pass the witness, Judge.
Thank you. Any questions of this witness, Mr. Mavono?
Well, no, Your Honor. I'll pass the witness. I call on Ms. Patel.
Okay, you may proceed.
Uh,
But Mr. Alonsky, did you want to call her since you're doing the prove up? Normally, I'd let each side call their own clients. So
I mean, if Mr. Bono wants to, all I was going to do is call Ms. Patel and ask whether or not the same questions would have been answered likewise by her. But if Mr. Bono wants to call his witness, I'm okay with that. So we rest.
I'm going to let him call his witness. Thank you, Mr. Alonsky. Mr. Bono, Ms. Patel, I need you to get your video up and running, though. You're in court, and the court needs to be able to see you. All right, Mr. Mavono, you may proceed.
Thank you, Your Honor. Ms. Patel,
Yes, sir.
did you hear the questions and the responses of Mr. Bakar? A while ago?
Yes.
Okay. Is there anything there that was asked and answered that you disagree with?
No,
So you are willing to go through with the divorce, is that correct?
correct.
All right. We'll pass the witness, Your Honor.
Mr. Lansky, any questions of this witness?
No questions, Judge.
All right, thank you. The court has reviewed your paperwork, and the court is granting the non-suit of the annulment, and I'm signing that order. Those two orders. The court's signing the order non-suiting the annulment, and the court is approving the agreements that you've reached. I'm granting your divorce. The lawyers have done a very good job on the paperwork, and I am approving that paperwork, and I'm signing your divorce decree. You can get a copy of this order from the district clerk's office here a little bit later on this morning. Okay? Thank you all for appearing this morning, and best of luck to both of you.
Thank you, Judge.
Thank
Are we
you.
excused?
Thank you, Mr. Lonsky. Y'all are excused.
Thank you, Your Honor.
Have a good morning.
You too. All right, gentlemen, give me 1 second. Let me finish this docket entry so I don't get behind, and then I'll take y'all up. Okay, and I've got the two orders that were filed by Mr. Zand on this matter. Mr. Kincaid, do you have an order as well that I need to be pulling up, or are we just dealing with these two orders this morning?
I don't, Judge. I need to apologize and say that I did not get an order drafted. And if we can get just a little more time, I told Mr. Zand I'd try to have that to him today. It's should be pretty short.
Yeah, I'll like to give you 10/29 because next Friday we have like 25 cases on a DWAP docket, so it's going to be a busy Friday. So I'll give you 2 weeks, Mr. Kincaid, for the entry on that order. And then if we have any changes to this order, I'll probably be giving y'all the same date for these orders as well. But it may be that we can enter these orders today. I don't know what all issues we have. So why don't we do this? Would it be easier, Mr. Zand? Normally what I do is, since you drafted the order, I'll have Mr. Kincaid go through any issues that he has with the order and then let you respond to them as he brings them up. But if it's more of a clarification stuff, then it may be that it's easier to have Mr. Zand do that, Mr. Kincaid. So let me know what, do y'all have a preference on the procedure?
Judge, I don't have an issue. I drafted the order. Mr. Kincaid's the one that brought I guess, the questions about whether or not that's what the order was or was not. And then we've got some clarification issue on the mailbox and usage of, and who's actually excluded from use of that mailbox.
Okay. All right, let's do that then, Mr. Kincaid. We're going to let you go through the order. Why don't we take up, would it be quicker to do, let's do the order on the motion to compel first, because that's easier.
I'm glad you clarified that that's easier because I think the other one's easier, but we'll do the compel first. You ready for me, Judge?
I'm ready, Mr.
Okay,
Kincaid.
I'm sorry. I thought you were looking for it.
No, I've got the order
All
pulled
right,
up.
so page 2, number 6 involves request for production number 8. And my notes talk about personally or in his sole name that he has to produce those. And I think
That's correct on the entities.
that's not listed anywhere in here other than in section D. And so I wanted that as a global blanket on this entire request or this compel. And then I had 2 questions about D specifically with regards to the way that's listed. I don't want there to be any misunderstanding that if he has withdrawal privileges on an account, that he has to produce it. If he has a DBA account, if it's his sole name or 100% ownership, then he'd have to produce it, but otherwise not.
Yeah, no, if it's an entity and he's not the sole owner of the entity, just because he has withdrawal privileges, that's still a separate entity. And the court's not ordering those documents to be produced by him. He needs to produce any documents that are in his personal accounts. Any DBAs are still going to be his personal account. Any entities that he's the sole owner of, he would need to produce those records. But other than that, parties are going to have to subpoena those records.
All right, so if we just add that kind of blanket to it before we get into what is A, B, C, and D, I think that'll be fine. Dean.
Mr. Zan, response?
I understand that's the court's ruling. So if I put in here is order to produce all accounts reflecting funds, mutual funds or accounts, statements, transfers and withdrawals from accounts. Where do you want me to put that in there, James?
If you want to put it,
To produce all accounts in his
personally in his sole name or he's the sole owner, just put that little blurb in there anywhere, probably right before number A or letter A.
Yeah, I think if you just cut and paste your language on D, because that, to me, that looks like good language, and just put that up. Either you can either put it in the the very first part of the request, of the order, or you can put it on top of A, like Mr. Kincaid's saying. Either place would be fine.
I'll just stick it I'll stick it in number 6. Tariq Mohammed Zaghloul is ordered to produce all accounts, and then
Yeah.
in his
that's
sole
fine.
name or name of an entity in which he's the sole owner, reflecting funds, and then so forth as it currently states.
Yeah, I think that reads that's a good way to do it.
And then just delete D. Number 7, Judge, that has to do with request for production number 9. Mr. Zand and I had different notes on that. I have that one is denied. Mr. Zand had that it was granted.
Because I have Kia, Mazda, he needs to produce those, Bank of America produce.
All right, my notes.
Can you tell from your notes, Judge?
Well, my notes from my hearing are on my bench. They're not in front of me, but I do. So I do remember the Kia being an issue. Let me look at the actual order. So this is all documents related to the value or character of the party's property?
Correct.
Yeah, see, normally that would just be he needs to do an inventory. Would normally be that, but then if he's got any appraisals or any documents that he's looking for to use for purposes of valuation, like Kelly Blue Book or anything like that, he would need to produce those. But normally my response on that is that you need to provide an inventory to the other side. And then supporting documentation. So Mr. Zan, you showed that I had something about a Kia in there.
I have, my notes say that he needs to produce the Kia and Mazda, I guess the values for those. And then I've got a BOA below that. So I just have dash produce. So that's why I included it, as I believe that you ordered that response needs to be produced.
Yeah, so on a car, I wouldn't normally do that unless I know there's something out there. So to me, that doesn't, if there's a.
Well, I think what the issue was, Judge, is he sold a vehicle, if I'm correct, right, James?
Oh, that's right. That's right. And so I said, if there should be records of the sale, right? And either there's bank accounts showing what money was paid. So yeah, that I did grant that, and that would be what we're looking for there. So, and it may be, Mr. Kincaid, that there's not documents, but there needs to be a response that says, there's not documents reflecting the proceeds from the sale if he just got cash and he never deposited it. But and that may be something y'all have to deal with in a deposition, to know what exactly took place and where the money went. But for purposes of discovery, I do remember that. And I said, if there's records of that sale, then those need to be produced.
Which would be why I have BOA below that, Bank of America, as you said, if there was deposits into the bank, that made sense.
Dean, let me just say this, these documents are due to you today, and because my notes said denied, I don't know if we'll have those documents or not.
I can agree to give you some time. I mean, Judge, you want me to extend it to the 29th?
We'll just keep it the same. I mean,
just do the extension to the discovery's due in 2 weeks. I'm sure Mr. Zan would rather get a full package than, piecemeal stuff. So let's just, y'all have agreed, and I think that's wise to just because there may be other issues that come up today where you're going to need additional time. So the deadline to get the discovery responses in are going to be October 29th.
And will that be for we've got James's. I have my office trying to work on them to get them supplemented today, but we don't have much to produce.
You extended him a courtesy. I'm sure he'll do the same for you.
Yes, for sure.
You'll have it before then though, James, just so you know.
I'm still bringing you the check today, so.
I'm not going to agree to an extension on that.
Okay. All right, Judge. Again, in number 8, which deals with request for production number 10, I had in my notes, again, sole ownership, 100% ownership, personal guarantees, but then I also had a note that CIB was denied, which is M. I don't know why. If we specifically went down the list or exactly what. I think that was maybe a business credit card or something, and why it was denied would be my guess. But do you have anything in your notes on that?
Mr. Zan, response?
No, so number 10, I have order produced, drainage, mortgage statements, credit cards to produce, and then I have mortgage statements again. So that's what I have on number 10. So it was ordered to be produced, and I think, James, you mentioned too, a Chase Amazon or something like that, and we put all Chase credit cards under G.
Yeah, I have a Chase Amazon listed in my notes in number 10, but we have all Chase credit cards, so it's probably the same thing.
Yeah, these were the photos that she had of all the credit cards, I think. And my thought on that is, if it's a corporate account, similar to prior consistent rulings, is that if that's an entity's debt and the community estate is not subject to any contingent liability there, then he doesn't have to produce that. And that's probably where my ruling came from CIB, because the credit card showed, or the evidence was that it was just an entity's credit card. But on these, if there's a personal guarantee on an entity's debt that has been signed by the parties, then that needs to be produced because that's a potential debt to the community estate. But otherwise, those documents that relate to an entity where he's a partial owner do not need to be produced. But so to answer your question, CIB bank credit card, it sounds like to me that was an entity's bank account that he was not the sole owner of, and that's probably why M was excluded. Do you have any notes, Mr. Zand, on CIB?
I don't, Judge. I don't have it listed anywhere in my notes.
Well,
And I honestly don't recall.
If we put the same language in there that if he's 100% owner, personally guaranteed, or in his sole name, then I think that would cover it one way or the other.
I think that's.
I put that under there, under the top, James, for where it states since January 1st, 2017, as requested in number 10, if in the party's personal name or if they have personally guaranteed.
Yeah, I think that's, or sole owner of the entity, you could add there, Mr. Zand.
Okay.
Because if CIB is solely owned by him, then he needs to produce that. So if you add that.
Added personal name, sole owner of the entity, or they have personally guaranteed, including but not limited to the following.
Yeah, this should be good. Judge, the next one is the order number 13 having to do with request for production number 22. I have that you denied it, but granted it in a limited capacity. But I don't say why. Personal guarantees, sole name he needs to provide. That's all my notes say.
Mr. Zand, response?
And I have listed number 22, produce if sole owner dash supplement. And so
I guess
I was under the impression you ordered to be produced, so it's included. And it states 100% ownership.
Which the parties are signatories.
Yeah, it has there on any entity owned 100% in which the parties are signatories. So I think that language is fine. And again, it may be that there's no documents responsive to the request, but I think the language in the order is fine.
Okay, so that one's granted.
Yes, sir.
All right, and then Mr. Zand and I agreed on changing some language on the last paragraph.
Okay.
He's just going to remove the judgment language with the interest.
So that will be, Mr. Zand, your entry on this order on the motion to compel will be reset to 1029 with those few changes that we discussed.
Judge, and I put Mr. Pursley's signature on this. Is that required, Judge? Because he wasn't, I guess, I don't know that he was part of this motion to compel because it wasn't on the intervener. It was against the respondent.
No, you mean you can leave his name on there. I'm going to sign the order, or you can delete it. I'm fine either way, but he didn't really participate in the motion to compel. So from that standpoint, it doesn't matter to me. It's going to get signed either way.
Okay, I've made those changes. I'm going to email it to you right now, James, so you got it.
Thank you, sir.
I mean, we do need to notify him that the entry's been reset to 1029 and give him an opportunity to appear. I'm not saying he doesn't have that, but he doesn't have to sign the order.
I just didn't want to, if Mr. Kincaid and I signed it, I didn't want to have to reappear at entry and take up more time and cause my client to incur any more expense if he's not going to sign it.
You won't need to.
Okay, thank you, Judge.
All right, we ready for temporary orders, Judge?
I'm ready.
All right, page 12. On the paragraph under section E.
I'm there.
I have in my notes that first payment is due today and then on the 15th of each month thereafter.
That's correct.
Okay.
I started that October 15th and on the 15th of each month thereafter.
Yeah, I had October 1st and the 1st, so I must have just heard it different. That's what I had. So I'll change that.
All right, I'm gonna ask this question, Judge, because I think there's just two more things. With regards to the mailbox, let's talk about that. You gave Miss El Sayed exclusive use of the mailbox. Mr. Zaglal is now saying, hey, my mom gets her mail there too. Is she enjoined from the mailbox?
I can't enjoin mom from the mailbox. Well, I guess I could now that she's party to the suit, but
because we just need clarification on that. So
yeah, well, I can tell you that wasn't part of my order. My order was that he was enjoined from changing the lock and he was enjoined from accessing the mailbox. But I didn't do anything with mom. So I understand, Mr. Zan, that there's the concern that mom might be going in there and stealing wife's mail, but that wasn't part of my order. So I'm not going to do it now. If that's becomes an issue, then the court will enjoin her from getting the mail and tell her she needs to have it forward somewhere else until this case gets resolved. But hopefully everybody behaves.
I just don't know why she would have her mail there if she's not there's no property ownership established at this point in time. And so my client's concern is that if she's allowed to go, then she's just going to do what Tarek was doing, Mr. Zaglul.
Well, but you can, the standard language on the injunction is going to say, all his agents and that jazz. And so there could potentially be an enforcement issue there. And, but I'm not, it wasn't part of my order, so I'm not going to create it in my order now. But I recognize that's an issue that I don't think any of us really thought about that at the time we were going through the hearing.
And Mr. Persley was present and he never brought it up as a concern or issue. So,
right.
But I would hope Mr. Kincaid would instruct his client that should not be.
Y'all know, if I'd heard evidence that mom was getting her mail there, or mother-in-law was getting her mail there, that I would have said, hey, forward your mail to a different address until this litigation's done. Because one, you want to make sure you get your mail, right? And if you don't trust the wife in this case, then why would you be having your mail delivered there? Because it just doesn't make sense. So hopefully y'all can fix that and without it leading to more court.
So Dean, then on page 17, where she's got exclusive and private use of the mailbox, I don't know how we carve an exception to that. Unless you just say not excluding Miss Masba.
My order was that she have exclusive use of the mailbox. So
okay.
I think we leave the language the way it is. And but no, I didn't enjoin grandma from doing anything. Her mother-in-law.
And then I think on the top of page 18, Dean, you agreed to put future on that top line.
And I've already changed that. Yeah, exclusive right to any and all future child tax credits.
Right. Okay, so in the middle of that page, Judge, you had ordered Mr. Zaglal to pay Mr. Zand, and you specifically mentioned from the Bank of America credit card 7466.
Yeah, y'all asked for clarification on that because I said 5,000. I don't care where he takes it from personally, but one of you, I think it was Mr. Zan, asked for clarification on which account, because I was just saying there's funds available. There was like a $25,000 line of credit or something that he could tap into. That in my brain, I thought, well, there's money that I can give interim fees, and I even said I think I would maybe utilize that to get both of you paid for a final trial. But I don't care where he takes the 5,000. It may be that he has 5,000 in an account that I wasn't focused on, but that's where I was saying he could. That I found there was resources there or credit there for him to get that money paid.
So I guess then the question is, the way this is drafted says he needs to pay Mr. Zand by cash, cashier's check, or money order. If that's from a credit card, does he need to process that credit card as a cash advance to pay him in cash? Can he pay him with a credit card? I mean, obviously that's just fees for Mr. Zan. He and I had this discussion earlier about the ridiculous amount of fees credit cards are charging everybody now, but
Yeah, I mean, I think that my order was he pay 5,000, so he would need to pay the convenience charge associated with it if he's charging it. So it may be that he charges 5,200 on his credit card or whatever, but Mr. Zan should get $5,000, was my
okay.
intent.
All right.
But if you want to add language in there that says he can utilize a credit card, so long as he pays the convenience fee, then you can add that language in to give him that ability.
I'll try, Dean, let me try to avoid that and just have him pay me, and then if he's gonna use a credit card, I'll have him pay me. And
You've
then I'll
already got
just
it in
send-
your contract that he's charged the processing fee, so.
Correct, yeah. So we'll do it that way. Okay. And then Judge, the only other issue is on page 22, then in under 29, where not in section, but the next paragraph under 29, where Miss El Sayed is enjoined from the Mazda CX-9. And then my question would be changing the locks on the mailbox. I know, well, I don't think you ordered that either, but I guess then if grandma's locked out of the mailbox, what do we do?
No, I believe he did order, Dad, your client prohibited from changing the locks, because that's what my client had testified he'd done in the past.
Yes, my client is enjoined. I don't disagree with you on that, but this is your client. And if she wasn't enjoined, then the mailbox lock could be changed, and then grandma's standing around waiting for her social security check or whatever.
Right, and I, same thing there. I did not enjoin mom from changing the lock. But and I really think mother-in-law needs to get her mail forwarded, but I did not enjoin her from changing the lock to that. I don't know that she has the authority to do it, honestly, because I don't know that she really can, just with an order that says she has exclusive use of the mailbox. She might be able to get the lock changed, but
well, here's the issue, Judge. She doesn't have access to the mailbox now. She doesn't have the key. Mr. Zaglul has the key and has refused to give it to her. And so she has no other option but to go down to the postal service and request a new lock be issued so that she can utilize the mailbox. Because right now she can't access it. She doesn't have the ability to access it.
So she's been living there for 2 years without access to the mailbox?
Your client changed it. So when she did change it one time, he went back, and that's the picture we presented with a drill out of the lock. And then he went to the mailbox or to the post office and had him change it, and they gave him a key. So she's never had access to it since.
Sure, she didn't drill it out, Dean?
No, she didn't drill it out. No, what she said is she went and changed it one time, and then that's when he did what he did. And now, because the post office gives him the key, she doesn't have access to it. So she would have to go down there personally, pay the $25, $50, get a copy of it. But she says they also give him a copy of it when he goes to the post office and requests it. So that's the issue.
so it sounds like she probably is going to be able to change the lock. And so mother-in-law needs to forward her mail. But if we need to, I mean, I'm not going to issue orders that I didn't issue. And then if it becomes an issue, hopefully y'all can work it out. But if it becomes an issue, then just set something with me and I'll try to work through it.
I think the only way, James, to avoid it being changed is if your client will turn over the key. That's what she was trying to have happen. If he'll turn over the key to her, then it doesn't have to be changed. And then we can address your client's mother's mail and figure out a way for that to continue to be directed to you or her somehow, so that it's not an issue until she decides what she's going to do.
Well, yeah, and I mean, y'all could always agree to something where it says, mother-in-law can check the mail on Fridays between this date and this date, and the wife agrees not to, take mother-in-law's mail outside the mailbox. You can do something that, as long as mom gets the key from dad, that probably will save you all the cost of having to rekey the mailbox and all that. So hopefully it can get worked out.
That if he doesn't give it, then we're left with no other option but for her to go get a new lock.
I'll I'm going to go to the office later, Dean, and see if I can finish up this stuff, and then I'll be by your office later this afternoon.
Okay, we close around 2 on Friday, so if that's going to happen, then you can put it off to next week, James. I don't want you rushing out if not necessary.
Okay, I'll see if I can get it done by 2.
Okay, because I got to go pick up my son from school.
Yes, sir.